Thank you. Be seated. The court is ready to hear argument in 12-617, Union Carbide against Synatzske.
May it please the court, Mr. Phillips and Mr. Tipps will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal. Mr. Phillips will open the first 10 minutes. Mr. Phillips will present the rebuttal.
May it please this honorable court. This case involves three issues. First, whether Senate Bill 15 is unconstitutional as applied to the Emmett's claim. Second, whether the constitutional question presented here can be avoided through a statutory interpretation. And third, whether this case should have been dismissed by the Asbestos MDL court because the timing requirements of Senate Bill 15 were not met. I will address the first two questions and Mr. Tipps will address the third. This is one of the first opportunities the court has had to apply its constitutional balancing test set forth in Robinson for retroactive statutes. The initial question that I think the court must address is the question it left open in Robinson, and that is, does the constitutional retroactivity clause apply at all to a cause of action that was merely created by statute and not by the common law? A wrongful death claim like the one the Emmets have brought here is purely a creature of statute. And this court has held repeatedly that a legislative repeal of a statutorily created cause of action results in the immediate dismissal of all pending actions thereunder, even one that's been reduced to judgment and is just pending on appeal.
How could the legislature have intended such a result where a defendant would be made to do something that they couldn't possibly do?
The legislature was and so let me skip to that, and I want to come back to why I don't think the retroactivity clause applies at all. The legislature, as set forth in its findings, which are tab 5 to our bench book, was faced with a true crisis, as this court has recognized in Robinson, recognized in Global Santa Fe, with all these asbestos cases exploding, Texas being the leading state in the nation for these cases, and with 70 companies already bankrupt and other possible defendants, suffer on the verge of bankruptcy. The legislature was concerned with preserving a limited pool of money for those who were seriously and objectively impaired. That is, people with mesothelioma or some other cancer, or those who could objectively show that they had asbestosis that had impaired them.
But they also provided for a safety valve when that would allow proof from other sources when a pulmonary function test wasn't available. And right?
No.
Okay.
Section 90.010 is a safety valve, and it requires a pulmonary function test that a treating doctor has reviewed. So, in other words, 90.010 did away with a lot of the requirements. And it did away with the specific levels that must be met by that pulmonary function test, but it still required the test. That's one of the elements, because that is the accepted medical way of deciding whether or not your asbestosis has created an impairment or not, is that test. And so it's an irrefutable requirement of proceeding to court under this statute is that you have one of these tests. Now, the concurring opinion of Justice Bland said, well, all you have to do is have the test. It's like a speed bump. And, in fact, Mr. Emmett had one from 40 years ago that was completely normal, so he gets over the hump. And somebody who didn't have one doesn't, which I think is an absurd construction. And the concurrence justified that on the theory that you need to interpret a statute to avoid a constitutional question. So they avoided the whole constitutional issue by making that interpretation. But tab 13 of the bench book is a recent opinion from the Supreme Court by Chief Justice Roberts that had this very issue. And he said, we cannot rely upon the canon of construction that ambiguous statutory language should be construed to avoid serious constitutional doubts. This court may impose such a limiting instruction on a statute only if it is reasonably susceptible to such a construction. We will not rewrite a law to conform it to constitutional requirements, for doing so would constitute a serious invasion of the legislative domain. So I think it's pretty clear that that the concurring opinion sets this test, as a majority of the court below held, sets up just a totally arbitrary, whether or not you happen to have this test or not sometime in the past, so that somebody who had one fairly recently that nearly met the requirements but didn't quite, that would actually hurt them. And somebody who's never had one is totally out of court at all, but someone like Mr. Emmett, who had them at his job 40 years earlier, that the doctor could not have relied on in making a diagnosis of impairment because they were totally normal and they were also too old, he gets to go forward. So we believe the court has to face the constitutional issue head on. Now, as I said earlier, I don't think this statute applies, is impacted, because wrongful death statutes are purely a creature of statute. And the court held that issue open in Robinson. But of course, in the open court jurisprudence, in Marino versus Sterling Drug, you said that the open court's guarantee did not apply to a wrongful death claim because it was merely created by statute. So to be consistent with that, you would say Article 1, Section 16 didn't apply. The Court of Appeals got around this by this sentence. They said that Chapter 90 is not a, quote, unqualified repeal, but only a partial one, and it does not, therefore, deprive a court of jurisdiction to proceed. Now, I think both of those grounds are specious. The term unqualified repeal comes from this court's opinion in Quick versus City of Austin, where the court used the term to describe a law that, like this one, did not limit the effect of a repeal. So this is unqualified under that standard. Deprivation of jurisdiction is a quote taken from Dixon versus Navarro County Levy Improvement District back in 1940. And back at that time, the court had held if you had a statutory claim and you didn't meet all the elements of the statute, the court lacked jurisdiction to proceed. And the court overruled that concept in Dubai Petroleum Company versus Kazi. So the plurality of the Court of Appeals here, Justice Jennings' opinion, just relied on some outdated language from a case to avoid this issue. But I think the court first needs to take this head on, which is, are you even going to apply this guarantee when it's merely a statutory cause of action, not a common law one? If you believe the retroactivity clause does apply there, then I think you have to look at the balancing test that you set up. And the plurality below, with Justice Jennings' writing, looked really at only one of the things the legislature said, which was that the purpose of the statute was to protect the right of people with impairing asbestos-related injuries to pursue their claims. Then they bought into the proof that the Emmets brought here and said, we think Mr. Emmett was impaired, and therefore we think he should be able to go to the jury. The problem with that is it totally undercuts the problem the legislature saw, which was all these people had asbestos x-rays, some of them taken from mobile units that were being sent around the state, and they might be able to convince a jury that they were impaired or they might not, but it was subjective, not objective. It creates a fact issue.
I thought the lower court made some affirmative findings that Joseph did in fact suffer from functional impairment.
The trial court found that, but that's not like a jury finding it. That was a finding to let it go forward. And the trial court said if you're dead, you're impaired. This type of theory gets rid of the whole benefit of this statute, which was to set up an objective way to see that only the people who could objectively show they were impaired got to trial because there was so little money left and you had so many claimants who had mesothelioma or proven objective impairment, and it was an attempt to save the fund for them. So it was a partial repeal of the Wrongful Death Act in just this kind of a case to preserve that fund. And the legislature made these findings about how many people had gone bankrupt, how many claims we had pending, how little money was going to be left for the truly impaired. And this bill had widespread support from an element of the plaintiff's bar and from the defense bar and manufacturers as a stopgap method because Congress had not chosen to proceed with a national solution, a stopgap method for Texas to preserve funds for those who most deserved them and to get more funds into the hands of the injured people rather than what had been the history to that point, which is most of the money went to attorney's fees and transaction costs. So we believe that reflects a compelling state interest, public interest in this statute, that it can be retroactive so that the claims on file tried one by one, like this one with a disputed fact, wouldn't eat up all the money.
And I confess, compelling is one of those gauzy, eye of the beholder, Rorschach test type words. And when is compelling not really compelling, but important? Not really important, but worthy. It seems so innately subjective.
This, of course, was the burden of Ted Olson's motion for rehearing in Robinson versus Crown Corp. But this court did say in the Robinson case that we are going to look to the legislative findings. That's going to be how we determine whether it's compelling or not. Of course, in the Robinson case, there were no findings. There was a statement added later by the sponsor. Here you have very strong findings set forth in tab 5 of the bench book, and we think if the court gives those deference, this statute would clearly withstand the test should you get there.
Any other questions? Thank you, Mr. Phillips.
Thank you.
May it please the Court. The en banc Court of Appeals opinion contains two flawed holdings on the timing issue. First, as demonstrated at tab 7 of our bench book, the Court found that the safety valve provision contains no deadline for filing a report that is compliant with its provisions. But in fact, by invoking the motion to dismiss procedure of section 90.7, the safety valve also invoked that section's strict time requirements. Second, as set out at tab 8 of our bench book, the Court of Appeals found that the Emmets demonstrated good cause by requesting additional time to file an amended death certificate. But that cannot constitute good cause under the statute, because under the statute, evidence that asbestosis caused death does not make a physician's report compliant either with 90.3 or with the safety valve. Under this statute, the Emmets should have filed Dr. Prince's report and invoked the safety valve on or before September 7, 2007, before the very first hearing. And because they did not do so, and because they did not seek an extension of that time deadline, Judge Davidson should have dismissed the case at that point. Now, the Court of Appeals was correct that the safety valve provision itself does not contain a time deadline. But the safety valve invokes section 90.7 for purposes of resolving a motion to dismiss. And section 90.7 contains extensive time deadlines. Specifically, section 90.7 provides that a motion to dismiss must be filed 30 days after a non-compliant report is served or an unserved report is due. The claimant then has 15 days to respond to that motion to dismiss and may supplement the response with an additional or supplemental report, which could invoke the safety valve. And the court then, at the end of that short process, is to grant the motion if, notwithstanding the response and any subsequent report, it is meritorious, unless the safety valve has been invoked, in which case there need to be additional procedures. I submit that is the only logical and only reasonable reading of this statute. And it is the reading that fulfills the goal articulated by this court in Re Global Santa Fe, that the physician report issue should be resolved, quote, early in the litigation so as to conserve judicial and litigant resources.
Counsel, may I interrupt you just a minute? Looking at your Exhibit 9 bench book.
Yes.
The UCC was served with a petition attaching the report on July 16th. Floor filed a report, or a motion to dismiss, and then on 8/23, UCC joined in that motion.
Correct.
Now, was that within the time limit? Didn't you have to timely file a motion to dismiss within 30 days of your being served with a report?
Well, Floor had filed a motion to dismiss, and we joined in that motion. I don't think there's any question with regard to the timeliness of our action. There is some, well.
I didn't recall that, and that's what I'm wondering. It seems like I recall the motion must be filed within 30 days after the non-compliant report was served or unserved. So you were served with the lawsuit on July 16th, had a report there. And the motion to dismiss then was filed. They had to file a timely file their report to you. So there's not any question that you timely filed, that your motion was timely.
I don't think there is, but I apologize to the court that I can't answer that question precisely right now, but I will do so in a post-submission filing. I don't think there's ever been any question concerning the timeliness of Union Carbide's
I didn't recall that, but I was just looking at the dates, and it seemed a little strange.
Let me address that later. Our position simply is that on September 7, 2007, the Emmets knew that Dr. Prince was a treating physician, and they knew that but for the potential problem of a pulmonary function test, the safety valve was arguably available. What they should have done at that point is file the Prince report and sought additional time to secure any pulmonary function testing that existed. What they did instead was lead Judge Davidson into error by making the baseless argument that Chapter 90 does not apply to wrongful death cases at all. That's why they wanted an amended death certificate. But that's not the way Chapter 90 is written. Under Chapter 90, except in cancer cases, you have to show impairment. And quite frankly, and it's clear under the statute, the fact that you can show asbestos was the cause of death does not make a report compliant. But they, rather than doing that, though, they waited until years after this report was initially due, and Judge Davidson ultimately denied the motion to dismiss based upon a safety valve report filed 2 years and 3 months after the statutory deadline.
Any questions of Mr. Tipps? Thank you, Mr. Tipps. We'll hear from the respondent.
Please the court. Mr. Chandler and Mr. Hogan will present argument for the respondents. Mr. Chandler will open the first 5 minutes.
May it please the court. I rise this morning to speak only to the issues of timeliness as to statutory construction and constitutionality. Mr. Hogan will address those issues. Now, first, as to the timeliness. This statute conspicuously leaves absent any timing requirement for a safety valve report. What the Union Carbide wants this court to do is to read into a requirement that the legislature considered and rejected. There is a timing requirement for a 90.003 report. It's clear the court wants to preserve judicial resources for cases that aren't impaired, and that's why a timing requirement should be there for cases that can never prove that they're impaired. Under a safety valve case, though, that is an impaired case, remember. The judicial resources economy argument does not apply to an impaired case because that is exactly the reason Chapter 90 was created, to preserve the judicial resources for men like Mr. Emmett. So that's why 90.007 clearly doesn't have a timeline. The other reason is 90.007 requires discovery to go forward. That discovery period certainly has to be a reasonable one. The court might look at this case and say, but it's 2 years later almost that we're considering the motion to reconsider. Isn't that unreasonable? And the answer in this case is clearly not. What is reasonable in one case may not be reasonable in another. The reason the motion to reconsider in the Emmett case or the Synatzske case that we're here to consider today took a while is because Union Carbide invoked the opportunity to depose Dr. McClure, the doctor who signed the death certificate. Dr. McClure tragically suffered an accident in which she was either walking or riding a bike and was hit by a car. She couldn't be deposed for well over a year and a half because she suffered a traumatic brain injury. What was reasonable timing in this case may not be reasonable in another when the doctor's across the street and perfectly healthy and can testify. So 90.007 requires only a reasonable time limit on a safety valve report. In this case, it was clearly reasonable because Union Carbide asked for the delay themselves. They couldn't get the deposition they insisted upon because that doctor was injured, and when she became available to give a deposition, the deposition was taken. Chapter 90.010 requires extensive discovery, so that's why there's no time limit for the safety valve exception. Now, what could have happened is that at the original hearing on the motion to dismiss, Union Carbide could have got a signed order and appealed that order within 30 days. They did not. They asked for the motion to reconsider. Because the motion to reconsider was pending, the plaintiffs then asserted their safety valve option. There is no restriction to, at one point, consider going forward under 90.003, and then later decide to go under the safety valve. Because remember, we're required to get discovery and provide exceptional medical evidence, and that takes some time to get it. And we can assert a safety valve after first proceeding under 90.003. What they did was seek a motion to reconsider, allowing the plaintiffs time to invoke the safety valve exception. I briefly want to discuss the arbitrary requirement of this case had a pulmonary function test where another case would, and to allow this one to go forward just because by happenstance we found a pulmonary function test would provide an arbitrary result. It's not arbitrary because this is why. Joseph Emmett, remember, was a 40-year insulator. He was a man who was required to get pulmonary function tests during his career because he was so heavily exposed to asbestos. It is not an arbitrary result at all to allow a man who is an asbestos worker who you would expect to have pulmonary function tests in his employment file to go forward, where another man might not because he doesn't have a job that exposes him to asbestos on a daily basis, where he might be expected to be impaired. This is exactly the reason the statute was passed, to protect men who were asbestos workers for 40 years who suffered like Mr. Emmett. Nowhere in this case are you going to find an attack on the factual sufficiency that he was impaired, and that's an important point. Chapter 9, the safety valve provision allowed Union Carbide to provide controverting evidence. They could have called their own doctors to address the impairment. They chose not to. I see I'm running out of time, and I'll address any questions before I sit down briefly.
Any questions of Mr. Chandler?
Thank you very much, Your Honor.
We'll hear from Mr. Hope.
Mr. Chief Justice, and may it please the Court, I want to first of all turn to how this statute is put together in terms of the safety valve, and then address the constitutionality question. But of course, noting that the Court does not need to reach the constitutionality question. That issue was adequately addressed, fully developed in the Robinson case. We see no need to return to that issue in this case. How is this statute put together? And this is tab 4 of my friend's bench book. If the Court looks under tab 4 of the statute, I'd like to point out two words that are not highlighted in that statute. In section 90.007, which is entitled Motion to Dismiss, you'll note that the first part of the phrase under subsection C is not highlighted. It says, except as provided by section 90.010 D or E. So, dismissal may be required if the report is not compliant with subsection 3, except if you fall under the safety valve, which is 90.010E. That's the first thing that's not mentioned, is that the word except is specifically, directly engrafted into the statute by the legislature. In subsection 10, 90.010E, you'll note that the motion to dismiss has to be granted, and again, not highlighted, at the end of subsection E, the word unless. If the claimant doesn't serve a report that complies, the MDL pretrial court shall, on motion by a defendant, dismiss the action under section 90.007 unless. And then the unless clause tells us that if you have a report under the safety valve and the trial court makes certain fact findings, which he did in this case, the most experienced judge in the state, the MDL judge on asbestos and silicosis cases, made specific, unchallenged, unappealed findings that this man had impairment that was the equivalent of the impairment that would have been shown under a pulmonary function test if one could have been taken. But of course, Mr. Emmett could not take that test because of medical and physical conditions that he had. He was demented, couldn't understand the instructions to take that test, which Dr. Prince's report says would have taken somewhere between 45 minutes and an hour. You have to follow complicated instructions. Mr. Emmett couldn't do it. He couldn't do it because why? Because the report of Dr. Prince says he had such shortness of breath, he couldn't even sit upright. Now, it's beyond the pale to suggest that the legislature, one of whose legislative findings was that impaired people need to have access to the courts and to leave unimpaired people at the end of the line while putting impaired people at the front of the line, that somehow somebody who is impaired, who has post-mortem autopsy slides showing thousands of asbestos fibers, and whose cause of death on that autopsy report is considered by a board-certified pathologist to be severe asbestosis. It's hard to imagine that the legislature would have overlooked its very purpose in enacting the statute and allowed Mr. Emmett's case to go away and say that no, the reason his case cannot be filed is because he doesn't have a report showing a pulmonary function test.
Is there evidence in the expert reports about how soon this came upon on him? I mean, he had been retired from working, I guess, a long time, and presented at the emergency room in what is fairly described as distress. But you wonder why he couldn't have the test a year before, 5 years before, some period closer to the end.
Well, I think it's a fair question to ask, well, why hasn't some of this shown up sooner in some of the medical stuff? Maybe because Mr. Emmett didn't go to the doctor a lot. Maybe because of his dementia that was creeping along for a long period of time and his Alzheimer's, he didn't complain about it. It is something that the legislature could have looked at and could have written into the law but did not, that something has to show up within a certain period of time. But it's noteworthy that under subsection 10, there is no requirement for a recent pulmonary function test.
But we're left with the speculation that he was impaired at the time. We have the pulmonary function test 40 years before. Do you agree that simply is a speed bump, as was described? That you just have to say that you've had one in order to qualify for the remainder of the test?
Justice Green, we're left with more than speculation. We're left with findings of fact.
Well,
the statute requires findings of fact and an interpretation of a pulmonary function test by a board-certified pulmonologist. Now, Judge Davidson found that Dr. Prince wasn't a testifier. He's not one of those people that goes around from courthouse to courthouse and plaintiff to plaintiff making up cases. He was the treating doctor that saw Mr. Emmett in the hospital because of his pneumonia when he came to the hospital. And he interpreted a pulmonary function test that we'll admit was old, but it's not Mr. Emmett's fault that it was so old. It's the one that could be found, and it was interpreted. And that's all the legislature requires. There's nothing more that it requires.
But it didn't show anything. I mean, there was no way to connect it to any impairment.
It did not. But the legislature doesn't require that pulmonary function test under the safety valve show any impairment. In fact, the safety valve wouldn't make any sense if the pulmonary function test required by the safety valve had to show impairment, because the whole reason there is a safety valve is because there's an alternative means of showing impairment. After all,
if there hadn't been the earlier test from decades before, and if Mr. Emmett were simply, as you put it, just really too impaired to even take the impairment test, would a court be required to? Would he have to go to the back of the line?
No, Your Honor. Mr. Emmett would have to do what the statute requires, which is comply with the safety valve alternative. Now, the legislature wrote that alternative into the statute because it meant for that alternative safety valve to have some meaning. And it seems to me to be a little bit strange for Union Carbide to tell this court that there's no evidence that Mr. Emmett's asbestosis ever resulted in any functional impairment.
What are you arguing that safety valve requires?
Your Honor, the safety valve requires this, that first of all, there must be some extraordinary physical or medical characteristics of the exposed person. So Mr. Emmett...
I don't mean that. I mean the proof that's allowed.
then the statute mentions what that proof would be. So the judge has to find that there's these extraordinary characteristics of the impaired person. In this case, that means that Mr. Emmett, because he was demented and because he couldn't take the test, had to fall under some other means of proving impairment. After all, the pulmonary function test is only a means for an interpretation by a licensed medical professional to say, well, I've interpreted the test and I think the test shows me impairment. But there are other ways that can show impairment when you don't have impairment shown by the test. And that's what the statute speaks to. It says that there has to be testing that has been performed on the exposed person, and the physician making the report has interpreted those findings. And then the physician has to find out, and this is under subsection 3, the person has radiographic, pathologic, or computed tomography evidence establishing bilateral pleural disease. Now, that's all what Dr. Prince found. A board-certified pulmonologist found that, who's the treating doctor, and that finding says that the medical conclusions, and these are in the clerk's record at page 757 and following, he had significant advanced asbestosis. Significant advanced asbestosis is probably the equivalent medical terminology for impairment. He has asbestos-related physical impairment comparable to the impairment the exposed person would have had with a pulmonary function test. That's in the clerk's record at page 346. So there are other ways. The legislature knew this.
But the finding was that it would have shown up on a pulmonary function test had one been given.
That's right.
Which indicates that we still go back to the pulmonary function test having a purpose. And your position is under 2. What is the whole, why even would number 2 be in here if we don't have to have an impairment by the pulmonary function? Why is that even in the statute?
Well,
if we just ignore it and say, well, we had one 40 years ago, and so now we've checked off that box. Why even have the box to check off?
Because, Your Honor, sometimes people don't get the testing that they always need, and it's not fair to penalize them because they're doctors or medical professionals.
I don't disagree with anything you say on that. But the legislature put number 2 in here.
Right.
Why is it in there? We don't presume they do a frivolous thing or something for no purpose.
We don't know from the legislative history, Justice Johnson.
Why would you say, what is your position on why it's here, other than just that they wanted to make someone jump through a hoop?
We believe that the legislature thought pulmonary function testing was a prevalent and accepted way of proving this, but that you must have at least gone across that speed bump or jumped through that hoop. But sometimes that might not work. It might not always show impairment. That there might be some extraordinary...
Let's assume that your gentleman did not have this pulmonary function test. It seems like he didn't have it, but you have the same findings, the same pathology report, the same diagnosis and all of that. The only thing is he did not have it. And I think that's the opposing counsel's position. This is a meaningless provision in the statute.
Because, well, I think the legislature could have imagined that they wanted people to at least try that avenue of approach. If that avenue of approach was not meaningful or there were extraordinary physical or medical characteristics of the exposed person that allowed for different proof of impairment, that the different proof of impairment could be shown as tested by a medical professional and as investigated by a trial judge. Because, Justice Johnson, in certain cases, and in this case the safety valve, is actually more onerous than a pulmonary function test.
If he had had the test, just say 2 months, 3 months earlier, and it had shown no impairment, your argument would still be if he couldn't take the test the day he presented at the emergency room, then he would still have the benefit of the safety valve.
Of course, it's unimaginable to us that 2 months before somebody has severe bilateral pleural disease that he wouldn't have had some impairment. But suppose the pulmonary function test wasn't functioning correctly, it wasn't calibrated, or the breathing tube was closed. There may be reasons why the pulmonary function test doesn't work, which is why the legislature put an even more onerous burden on Mr. Emmett than it would have on somebody who just flew into the tube and got a positive reading on the PFT.
But
A trial judge has to...
But to be sure I understand, it would be your argument that even if, no matter when the test had occurred, this one was years earlier, and if it showed no impairment, still he would get the benefit of the safety valve if he couldn't take the test when he presented in the emergency room.
I'm not sure, Your Honor, that we would have been making that argument, but
Well,
I would say
maybe you would or you wouldn't, but
the legislature
I'm just
would
trying to get an answer from you on whether you think that is the consequence of your argument here.
the consequence is that the legislative language has to be followed, and if that's allowed by the legislative language, then, of course, it could have been proven. But that has to be tested. It has to be tested and findings made by an experienced
Shift gears,
trial
you've got about
judge.
a minute and a half, and if you want to say anything about constitutionality, retroactivity, we may not get there, we may, but I want to hear what you have to say.
Your Honor, we would say what this court said in Robinson, and that is simply this, that necessity alone cannot justify a retroactive law. That's at page 145 of the Robinson case. In all of the findings, in all of the legislative history, you will not find a single instance in which there is a legislative finding that they wanted to do away with wrongful death cases for people who died before the effective date of the statute and filed their lawsuits after the date of the statute. And this whole argument about partial repeals runs directly in the face of the quotation that I just read you, which is that necessity alone cannot justify a retroactive law.
What about the threshold issue of whether the clause even applies to statutory claims?
The clause, whether it applies to statutory claims, is this. That imagines that a legislatively creative right of action like the wrongful death statute can never be a settled expectation, because the test under this court's Robinson opinion is whether settled expectations are disrupted. And the argument simply is that you can never have a settled expectation if you get your rights from the legislature, because those legislative created rights can always be taken away. Well, that would mean they could never be settled except maybe for 2 years while the legislature's not in session. And then they would become unsettled every 2 years when the legislature comes back across the street and starts meeting again. It is not this court's holding and never has been this court's holding. And Union Carbide would be taking this court where it has not gone before, and it would be taking this court to a place where the court did not go in the Morton Salt versus Wells case, a 1934 opinion of this court, in which the court recognized that wrongful death claims are not just statutorily created. They're found in Article 16, Section 26 of the Texas Constitution, where the Constitution recognizes wrongful death claims as having been allowed for the heirs of the body of somebody who's injured through gross neglect. Now, that kind of claim, being constitutionally created, cannot be repealed by legislative enactment, and it seems to me that it would be a surprise to everybody in this state if anybody in this state were to say that wrongful death claims aren't a settled expectation after they've been existing since Lord Campbell's Act.
Any other questions, Mr.
Can you clear up, are you challenging the timeliness of the motion to dismiss by Union Carbide?
No, Your Honor, we're not. I'll let Mr. Tips off the hook on that. But I would remind the court that it was Union Carbide that did ask for the motion to reconsider, which was still pending all the way up until the findings of fact were decided.
Thank you. Thank you, Mr. Hogan. Mr. Phillips, you have 5 minutes.
The legislature recognized that under medically accepted standards, if you go to a doctor complaining of shortness of breath and presenting a history that might lead one to think that asbestos could be involved, the doctor is going to perform a pulmonary function test. That's not something that you have to request or plead for. It is the accepted medical procedure. And in the findings that accompany this legislation, the legislature said that to the end of protecting the rights of the most seriously impaired, the Act adopts medically accepted standards for differentiating between individuals with non-malignant asbestos-related disease causing functional impairment and individuals with no functional impairment. If you get rid of the test, then you are going to have a swearing match as to whether or not autopsies are other type of medical examinations or show enough markers that this person would have been impaired, even though the person never had the standard test that shows impairment.
But what about these extraordinary situations where they're just not possible?
Well, the legislature found that 90% of the people that have asbestosis don't have any impairment. And so it's a gradual process ordinarily. It's not something where one day you're fine and then you all of a sudden have such impairing asbestosis that it threatens your life. The premise is reasonable, and the legislature would be reasonable in making a general rule that if asbestosis is impairing you to the extent that you could hope for a significant recovery in court, you are going to go to the doctor with some complaints, and the first thing the doctor is going to do is to give this test. And if you craft some, I don't know how you would craft an exception to that for Mr. Emmett that wouldn't swallow the rule. It wouldn't say that anytime someone comes in and says the decedent is dead, and we have a doctor who's going to say that the autopsy shows that there was such a high level of asbestosis that decedent must have been impaired, so we get to go to the jury on that, which is essentially the holding of the MDL judge. You are going to swallow up, that exception will swallow up this rule, which says we're going to try to preserve this limited pool of funds for cancer patients and for those who didn't have cancer but they had asbestosis so bad that we know they'll be able to make a serious claim and get a substantial award from a finder of fact. This case, we know he had asbestosis. We simply don't know about the impairment. He didn't go and get the fundamental marker test you always get if you are impaired. And so Judge Davidson's findings are irrelevant in terms of what would go on from here. If this goes back, it goes to a jury. Each side hires up experts, and it goes to trial. And the lawyer's fees almost certainly exceed whatever money, if any, the heirs might get in this case, which was the very evil that this statute was designed to prevent.
What do you make of Mr. Hogan's argument that wrongful death claims are not really creatures of statute, but they have a constitutional footing?
Well, I've forgotten Morton Salt. I'll say forgot rather than never knew. But I think there was a very scholarly battle between Justice Spears and Justice Doggett in Marino versus Sterling Drug. And Justice Doggett brought up all the arguments about why this was constitutional based, why it was really common law based. And the court 6-3 rejected that. So I'm going to go back and look at Marino, and if it said, but of course we don't mean the drug case from 1934, I'll submit a letter.
Any other questions of Mr. Phillips? Thank you very much.
Thank you.
That concludes the arguments in the case, and the court will take another brief recess.
Rise.